Are we ready on Duff?
Ready.
People against John Mark Duff, 22B141576B. Morning, Mr. Duff. Your name?
Good morning, Your Honor. John Mark Duff.
Good morning, everyone. DB1520 on behalf of Mr. Duff, who is present via video. Date time set for sentencing. I have had the opportunity to speak with Mr. Duff. I've gone over the pre-sentence report. I just asked for the opportunity to have it prior.
Sure. I'm trying to figure out, Lisa, can you tell me what the bond is that Judge Hessen was, or Judge Kirsten's referencing, or Judge Hessen rather is referencing this A file, 86A, it looks like.
There was a personal bond set on June 18th of $1,000.
I see. So he has not been in custody on this at all, correct?
Well, if it was a personal bond, then no.
What is he in custody on?
He's in custody for a probation violation of the Third Circuit.
I see. When was he incarcerated on that?
On Memorial Day, so he's been in there for 29.
How long have you been ordered incarcerated on the probation violation, sir?
He's just.
I have court on the 9th of July, Your Honor, for that.
Well, you don't show up in court. All right. Have you reviewed this report? Are there any material additions, corrections, or deletions?
No, Your Honor.
Anything you'd like to say on his behalf?
Yeah, so when this happened, when he failed to show for the original sentencing, his mother was in hospice. She actually died 3 days after his sentencing. Obviously, that's no excuse to not show up. Just explain kind of what he was going through personally. He has been incarcerated since Memorial Day. He thought it was on this case. Part of his probation was to get a GPS tether. He does have that on. He's hoping to be
On the other case,
on the other case.
Okay.
He's hoping to be continued on July 9th. If this court wants to sentence him to a term of incarceration, we're just asking that it take into consideration 29 days that he's been there. And hopefully a sentence that would allow him to get out on July 9th if his probation is continued in that matter.
Anything you'd like to say, Mr. Duff?
Your Honor, I don't have any excuses for my actions. So, I mean, other than I've been seeing some substance abuse classes while I've been in here. I see the power in numbers, with NA and stuff. I don't have any excuses for not showing up to your court, your docket that day, though. I apologize.
You don't show up anywhere, though. You're not just isolating us in your decision making. You didn't show up. You got a warrant out of. I'm just covering what I consider to be the bigger ones. You got a shoplifting warrant since 15. You got a DUI, operating under the influence of drugs, from 21, both out of Lincoln Park. You got another bench warrant issued out of Dearborn Heights for a controlled substance violation that happened subsequent to this. You need to get your life in order.
I understand, Your Honor. I know I do. It was a workplace injury, and the same thing that happened to a lot of the country. I was prescribed medication. It skyrocketed,
What year did that occur?
In 2008 at Bruce Steel, I broke my back, and I was on prescribed medication for a long time. I was working on it, and then I was cut off of it.
been since Memorial Day, which was the 26th, you said, correct?
Yeah, it'll be 29 days today.
200 fines, 400 costs, 75 victim choice fee, $50 justice assessment, 7.25 in 75 days. I'll give you credit for the 29 days that you served. I'm going to add 15 more if you don't pay your fines and costs. And I'll let you pay those at the rate of $25. Now, I'm going to make it $125 per month. And I will start that beginning October the 7th. If you are still in custody, you can write me a letter. So you're going to serve 46 more on this case. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. I really hope you get your life in order, Mr. Duff. Best of
Okay,
luck.
thank you, Your Honor.
Thank you. Thanks, Mr. Duff. Thank you. People against Garrett. Amanda Justine Garrett. 25T700567. Is Garrett out there somewhere? Okay.
Yes,
Your name?
Amanda Garrett.
Okay. Why are you appearing by Zoom? Is there a reason?
I'm in a treatment center.
I see. Okay. All right. So I have a charge here that alleges that you failed to submit the monthly testing as ordered on June the 6th of 25. That's count one. Do you understand that charge?
Yes, I do.
Count two alleges that you failed to provide written verification of attending and completing intensive outpatient treatment with aftercare. Do you understand that charge?
Yes, I do.
If you plead guilty or if you are found guilty of either one of those, or I should say both of those are two separate violations, you could receive 10 days in jail. Do you understand that?
I do.
You are presumed innocent. They have to prove you guilty by a preponderance of the evidence. You have the right to remain silent. You have the right to question their witnesses. You have the right to testify if you so choose. You have the right to bring in your own witnesses, to use the subpoena powers of the court to bring in those witnesses. And if you plead guilty, you're giving up all those rights, including your right to a contested hearing. Do you understand that?
Okay.
Are you talking to somebody?
Just my case manager.
You need to talk to her about something?
No.
Okay. Do you understand everything I said?
Yes, I do.
Understand if you plead guilty, you're giving up all those rights and we're not going to have a hearing of any kind.
Okay.
You understand that?
Yeah.
All right, just relax.
I know, I'm sorry.
All right, you have the right to a lawyer. I'll be happy to provide you with one at public expense. Would you like one?
Yes.
Okay, I'm going to enter a not guilty plea for you.
Yes.
We are going to set you up with an attorney,
Okay.
and then you're going to come back in front of me after you meet with the lawyer in a breakout room, okay?
Yes. Okay. Thank you.
Are you all right?
I'm just really nervous. I'm just had an emotional breakdown.
Just relax.
Thank you, Judge McNally.
How long have you been in the treatment center?
14 days.
Is it helping?
Yes, it is. I'm really working on my mental health this time around. My mom got injured for the millionth time this year and sent me into an emotional relapse.
All right.
Only emotional. I didn't reach the point of consuming any alcohol.
Okay, we'll set you up with a lawyer right now. And
All right.
okay, and then you're coming back. Thanks.
Thank you, Judge.
David Allen Story, 25T708117. Good morning, Sergeant.
Good morning, Your Honor.
Your appearance,
Sergeant Aaron Bernard, Police Department.
please your right hand. You solemnly swear affirm on the penalties of perjury, the testimony you give in these proceedings will be the whole truth, so help you God.
I do.
Okay, go ahead.
Your Honor, on March 4th, 2025, at approximately 5:45 p.m., Trenton Police Department officers were made aware of a police pursuit initiated by Wyandotte PD for a hit and run crash. Patrolman Fields from Trenton PD observed a fleeing vehicle on southbound West Jefferson and Sibley Road entering the city of Trenton. Patrolman Fields was in a full police uniform, fully marked patrol car. He activated his emergency lights and sirens and began pursuing the vehicle. The defendant vehicle disregarded a red light at southbound West Jefferson and King Road and accelerated 50 miles per hour in a 25-mile-an-hour zone, residential zone, including past a park located on West Jefferson. The defendant's vehicle became stuck in traffic on West Jefferson and West Road. Patrolman Fields and Patrolman Lipa from Trenton Police Department approached the defendant's vehicle and observed the lone occupant of the vehicle and later identified as the defendant, David Allen Story, white male, 7/27 of 1973. The defendant was placed under arrest and taken to Corwell, Trenton for a blood draw. A blood sample was analyzed by the Michigan State Police Laboratory with a result of 0.317 grams of alcohol per 100 milliliters of blood. The defendant's driving record is also listed as revoked with 6 prior alcohol convictions. Referring to the 2 prior alcohol convictions for the third offense notice, we're showing December 17th, 2003 out of the 82nd District Court, as well as July 25th, 2012 out of the 34th Circuit Court.
Okay, was there an accident?
Not an accident, I'm wondering if the prosecutor got confused, because it was an accident in Wyandotte. And I think they listed that as the third offense notice, but
No, but on fleeing,
on the fleet elude, right,
he wasn't fleeing and eluding at the time of the accident in Wyandotte.
that we know of. But I think the third offense, or I'm sorry, the third degree, he goes through a residential zone in a park also, so I don't know if that covers it or if that's second degree.
Okay. I didn't hear you say that there was an
Yeah,
accident.
there was no accident in the city.
I was kind of thrown for a loop there.
Right,
Give me one
I was
second.
reading that myself.
Give me 1 second here. Oh, wait a minute. What street was he fleeing and eluding on?
The entire time was on West Jefferson.
Yeah, so. And the speed limit is 35 miles an hour there, right?
Not when you have after you go south, past Truex, it drops 25.
Okay.
Residential.
But it's at least it's 35 miles an hour or less is, I guess, the way it's
Yes,
put in.
yes, right.
So I'm gonna make this. All right. I'm gonna strike. Just give me 1 second. I have to change this on both the complaint and the warrant. If you just give me another minute. So I'm just going to change this. I'm going to strike which resulted in a collision or an accident. I'm going to add in an area where the speed limit is 35 miles per hour or less. The court authorizes the complaint. I find probable cause to believe these crimes were committed. OWI 3, you do have the drive while suspense revoked, denied second. And there's sufficient evidence for the prior conviction giving rise to the habitual second notice, which was back in 2012, the conviction for OWI 3. You've already signed the complaint. Now I'm going to go ahead and sign it and date it and initial the change on both the complaint and the warrant. Okay, I think that covers it.
Thank you, Your Honor.
Have a good day.
You
Thank
too.
you. Bye now. Okay. Whose is this? Whose case is this? What's your name, sir?
Connor Fenwick.
It's an in custody arraignment, Your Honor.
This is for a probation violation, right?
A violation and then an arraignment on another charge that he was never arraigned on.
I need to get the probation violation. John, take this over to probation. Tell him I need the probation show cause that we're here for, please. I'll take this one. So you just take that. I need to do that for the probation violation. Yes. Connor Dennis Fenwick, 22B142398A.
Good morning, Judge. Attorney Corey Westmoreland appearing on behalf of Mr. Fenwick. Mr. Fenwick, would you please state your full name for the record?
Connor Fenwick.
All right, so let's take the probation violation first. I agreed to take it under section 7411. I sentenced him back in, let's see. Lisa, can you tell me what day I sentenced him? I can't tell. I neglected to date this on here, believe it or not. I placed him on probation for 18 months.
October 25th of 2023.
All right. So he was supposed to be here in April of 24 on a violation of probation. Failure to pay fines and costs, failure to submit the biweekly testing is ordered on April 16th. Those were the two charges. How is he going to proceed on those?
That's correct, Your Honor. And at this time, after speaking with Mr. Fenwick, we are proposing to waive any sort of contested hearing and enter a guilty plea.
Is that right, sir? Is that what you want to do?
Yes, sir.
If you plead guilty here, since you've absconded, you could get 90 days. Do you understand that?
Yes.
You're entitled to a hearing. You're entitled to remain silent, to testify, to bring in your own witnesses, to use the subpoena powers to bring in your own witnesses. If you plead guilty, you'll be giving up all those rights, and there will be no hearing. Do you understand that?
I do.
Call in Jessica, please. As to count one, that you failed to pay fines and costs, balance owing $45. How do you plead?
Guilty.
Count two, failure to submit the chemical testing is ordered on April 16, 2024. How do you plead?
Guilty.
You failed to submit the testing on that date, and did you also fail to pay your fines and costs?
Yes.
Anybody in the world forced you to plead guilty?
No.
Plea is accepted. Geez, he just doesn't like to show up. Then he didn't show up after Judge Kirsten arraigned him. This is bad news.
I understand that, Your Honor. And I turned myself in to Monroe, and I'm taking all the right steps to do the right thing. I
right.
don't want to live that life no more.
Mr. Westmoreland, well, first of all, Ms. O'Donnell, what would you like to say?
Just put on behalf of probation, Your Honor.
What would you like? Go ahead.
The only thing he's completed was the court work program days. He was in treatment at one point. He did go to rehab for a little bit, but I can never get him to stick with the program, Your Honor. I haven't heard from him in over a year.
Did I as yet revoke his 7411 status, Lisa? I don't believe I did. Doesn't indicate on here that I did.
No, you didn't.
All right, counsel, what would you like to say? Anything?
Your Honor, Mr. Fenwick did turn himself into Monroe County where he just did serve some time. Then he was picked up by Wayne County because he had some pending matters. As you mentioned, he's now sober, wants to clear everything up and get everything behind him. On release, he will be working for a mobile company. So he's just trying to get his life back on track.
I really am, Your Honor. I want to do the right thing here.
I also have to call this other case. Oh, wait a minute. Just let me, bear with me 1 second here. Does he stand mute and wait for my reading on the retail fraud? This is 24W83705.
That's correct, Your Honor.
All right. I'll enter a not guilty plea. Indicate you stand mute. I need another bond. Oh, here it is. I'm going to go ahead and set the bond conditions on that. This is, you cannot leave the state without the consent of the court or violate any law or ordinance. You must appear in court as directed, no contact with the victim. You're not to enter 23800 Allen Road in Woodhaven. No contact with the prosecution witnesses, no contact with employees of the Woodhaven Walmart. And I'll give you your choice. Do you want a cash bond? Does he want a cash bond, you think? He's going to go to jail on this other case.
Yeah, I believe that would be appropriate, Your Honor.
So 1,510% is your bond on the retail fraud with those conditions. I'm going to give you a court date. You're going to be in front of Judge Hessen. I will do it on July the 2nd at 10:45. That will be in front of Judge Hessen. Okay. Now, on this case, I'm revoking your 7411 status, entering the conviction, and he owes how much in fines and costs right now, Lisa?
It's paid in full.
He's paid it in full? All right, so I'm going to sentence him anew. I see no reason. I need another first page. I don't know what I did with the other one. I see no reason to put you on probation any longer, so I'm revoking the 7411 status, entering the conviction. I just want to talk about how many days credit he has coming. He did 4 on the court work program, you said.
And
And
3 days jail that he originally did. And then I do have that he did 5 days in rehab, if you'd like to include those days.
I don't think I ordered him to do that, though, did I?
I believe it was Judge Kirsten was here to do that, and I ordered him to do it.
All right. Anything else anybody wants to say?
I just want to state that I really do want to do the right thing and get my life back on track. I have a 9-year-old daughter that I have full custody of, and my parents are struggling to take care of her. But like I said, I turned myself in, and I want to be on the right track in life. I'm tired of running and everything else I've done. I deeply regret everything I did, and like I want to be on the right track.
100 fines, 200 costs. He's paid everything else, so we're gonna do $300 in 45 days. I'll give you credit for all 12 of those. You're gonna serve 33 more. If you don't pay fines and costs, you're gonna serve 45 additional days after that. I'm gonna let you pay this at the rate of $50 per week, and I will begin this starting September the 12th, okay? September 12th. If you need more money, you let the court know, or more time rather, to pay your money, I'll be glad to give you an extension, okay? You
All right,
just
thank
call the
you.
court, we'll go on Zoom, or you can come in here on or before any due date, and I'll give you an extension. I sincerely wish you well.
All right,
Good
thank
luck.
you.
Thank you.
Thank you, Judge.
I don't know what to take next. Andrea Lynn Brewer. 25B 148214. Your name, ma'am?
Andrea Lynn Brewer.
Counsel?
Good morning, everyone. You can get me back to 0. Yeah, was Brewer, who was emailed that.
Just for on behalf of probation.
I entered a not guilty plea. She said she wants a lawyer. She's charged with 2 counts of testing positive. How's she going to proceed?
My only question relates to the first violation. To my understanding, she wasn't sentenced to probation until May 21st. So
She was on bond conditions at that time, Your Honor.
so I think the first one would be a bond violation and not a probation violation.
That's true. I'll dismiss that.
Thank you.
Yeah, when they're on bond.
We didn't get the lab results till after.
I get it, but yeah, I'll dismiss. Count 1 is dismissed.
And she would plead guilty to count 2.
Is that what you want to do, ma'am?
Yes, sir.
If you plead guilty to that, that would be a violation of probation. You don't have any priors. You could get 5 days on this. Do you understand that?
Yes, sir.
And did you sign an advice of rights and read and understand the rights?
Yes,
If you
sir.
plead guilty to count 2, you'll be giving up all those rights, and there will be no hearing. Do you understand that?
Yes,
Is the
sir.
count 2 that you failed to refrain from consuming alcohol or drugs testing positive for cocaine on May 27 to 25? How do you plead?
Guilty.
Did you use cocaine, say consume cocaine within the 1 week preceding that, ma'am?
Yes, sir.
Anybody forced you to plead guilty?
No, sir.
And you still wish to do that, correct? Plead guilty?
Yes, sir.
Plea is accepted. I find it to be an accurate plea made voluntarily and understandingly. So count 1's dismissed. Count 2, I'm accepting her plea. What do you have to say here? She just was placed on probation. It's 3 weeks ago, a month ago, I guess.
So, she has done a significant amount of her community service. I know it's due on July 1st, but she has almost 14 hours done. She did start her IOP yesterday. It's gonna be 3 times per week for 3 hours. She's also going to Downriver Guidance Center. She's testing there 2 times per month. And then she sees them, I believe it's 1 time per month. She had been doing AA until she got in there. She's gone 16 times. She has paid in full, and I think she's had 4 clean tests since the positive test. She's working as a DoorDash driver. I'm just asking that the court, if anything, add some community service, possibly give her an extension on the original community service. And due to the new IOP and the fact that she'll be doing 9 hours a week there. And we're just asking that she be continued.
I gave her till July 1.
Right.
Why aren't you done with that yet, ma'am?
She's almost done.
How many hours have you done completely?
14,
So she still owes 10.
right.
And you're testing weekly, right?
Yes, sir.
So,
She's also testing additionally with downriver guidance twice a month.
all right. Ma'am, is there anything you would like to say?
I'm doing my best. I'm a lot better person for all of this. I'm so glad that this happened so that I can get my life together.
Yeah, you gotta stay off the
It's
drugs.
helped me so much. I mean,
Good,
I'm a way different person than I was when this first started.
that's good.
Judge, she did have a rough start to it, but she was honest right away that she used and that she wanted to get help. We got her into the guidance center right away. She's been doing great with there. She's tested timely for all of her tests since this positive test. They've all been negative. I have proof of her AA. She's got proof that she's doing her community service hours. Again, I think this was just a rough start to things, but things are looking up for her.
Good enough. You're to test weekly until September 1, then bi-weekly for 2 months, then monthly if you're clean. So if you stay clean, September 1, you're going to bi-weekly for 2 months, and then you're going to monthly testing. Serve 1 day on the core work program, pay $35 for that, pay additional costs of $100. Community service hours ordered at sentence to be completed by July 21. So I'm gonna give you a little extra time on that, okay?
Thank you, Your Honor.
So can you pay the 135?
Yes.
Okay, so you pay that today, you take care of this, stay clean. Okay,
Yes,
stay
sir.
clean, good luck, thank you, thanks. Gregory Allen Pugh. Gregory Allen Pugh Jr., 22B 141450, 21B 87514.
Right, Your Honor. Good morning, Will Lincoln, B 1520 on behalf of Mr. Pugh, who is to my left, statement for the record, Mr. Pugh.
Gregory Pugh.
Well, I hope he's got the money to pay.
We have a significant amount of it. It appears that last time this attorney somewhat did him a disservice. He told the court that Mr. Pugh had a job, he had a job interview, he didn't get that job. He does have a job currently working at Superior Windows Corp. He has a letter from his employer. It includes the employer's name, phone number, if the court wants to contact him. He does work Monday through Friday, 7 a.m. to 4 p.m., earning $20 an hour. Really, if we could get a 3-week adjournment, we'd have all the days in full. But we're open to whatever the court wants to.
Your Honor, may I speak? I was really hoping on having the job at Holbrook Auto Parts the last time we spoke. And when I went in there, they said that they were going further with other candidates. And I was looking for jobs everywhere. With me having a felony, it was very difficult. I did get employed at a Windows Superior job on June 11th. And I've been working there since.
Doing what?
I do, I take out old windows, put in new windows if you need them.
How many hours do you work?
On a daily, 6 to 8 hours a day,
How many days?
5 days a week,
So you're working 30 to 40 hours. How much do you make per hour?
$20 an hour.
So you're making $600.
Yes, Your Honor. I have a work letter.
Up to 800. I'll believe you.
Yes, sir.
How are you gonna come up with this money in 3 weeks? How much do you have today?
Today I have $600. Yes, I just worked on June 11th and that's my whole, I only worked 3 days for that. So I got a 3-day check, but my boss gave
And
me
you have $600 in cash.
cash today. I tried to pay them. but-
I'm gonna set a $600 cash bond. I'm gonna adjourn this. You come up with the rest of the money. but I can't keep doing this.
Your Honor, you're right, and everything I've done was wrong. Like I stated last time, I am not trying to be or do what I have been doing. I am trying to turn. my
Well, that's
life
good.
around.
Lisa, give me a date a month out.
July 22nd at 8:30.
You gonna have the money by then?
July 22nd, what would be the remaining balance?
If you pay 600 in a bond today, that will apply. You'd have 1329.04 to pay.
I also have a bond for this charge,
That his grant was willing to sign over. I think it's
$740. I have all that receipts, all that here.
Do we have a $740 bond on this already, Lisa?
I think it was 700 and there was
Let me check.
processing fee of $40.
I have the date for August 19th, 2022.
That might be the whole,
No, is he talking about the bond from 2022?
You forfeited that a long time ago.
Okay, I just wanted to make sure I could clear that. If I could, I would.
You put $600 down on your bond. Come back on this date. We'll work it out, okay?
Okay, you said the remaining balance.
would be 13 something.
Okay.
It'd be 13, I think that was 19, yeah, 1329.04. After you pay the 600. All right, good luck. We'll see you back here. Thanks.
Thank you, and if I'm having any kind of issue with coming with the $1,300, is it okay to call you and state maybe another 2-week extension, or just come in with what I have?
Jeez. Hang on a second. Hang on 1 second.
Because I'm gonna say I'm 90% sure, and I'm gonna try everything I can in my power to make sure I have it.
Hang on a second.
Yes, sir.
Lisa, I always also on 22B141450. He's got a bunch of violations from that. You owe 710 on that case. That's on the controlled substance charge. We're gonna adjourn that one 3 weeks, just for the record, too. Or to July 22, you gave me at 8:30, is that right?
Yes, that's correct.
So we're gonna adjourn them both to July 22. So you're gonna have to be sentenced on both. You understand that, Mr.
I
Pugh?
do.
So get your date down the hall. I don't know how to answer your question. I can't really take a phone call. And,
I'm just saying, because last time you said to call into the courts and let you know my issues.
well, I said, I tell everybody, if you don't have the money, you come in, you call the court, we'll go on Zoom. I tell everybody that, or come in here voluntarily, but that is a little bit different because this is not, I'm not setting a payment plan now.
Understood, Your Honor. Is there any way to get it more than 3 weeks? I don't think he took into account the other 700. He thought some of his bond would go towards it, not realizing that was the.
Well, the $710 one, I can work that out with them. I'm not worried about that as much as I am the restitution on the other case.
Understood.
Yes, so
So 1329 and 3 weeks.
July 22nd.
3 weeks, like 4.
You need more time? I thought you told me, maybe I'm
I
missing.
really love more time. I mean, I'm not asking for 4 or 3 months, a month and a half, I can be more comfortable knowing I can pay you that money without, I'm here today. I did not show up
Lisa,
today.
give me a date 2 weeks later, will you?
I just don't want to come in here.
I got it.
But
August 5th at 8:30.
August 5th at 8:30.
thank you. That's extremely possible.
Jeez. August 5th at 8:30, okay?
Thank you, Your Honor.
I wish you well, I really do. Good luck.
Yeah, thank you for your patience.
No problem.
Good.
Diamond Gee? 2522B141007. You keep pushing me, showing up late like this. Why are you showing up at 11:15 for a 10:15?
I didn't know that it was, I didn't know what time it was, I just came in as soon as I could. And I never showed up
You haven't?
late. No,
Well, let me see here.
it's my first time ever coming in this late, I always be here.
Doesn't look like you appeared on October 12th of 22, nor did you appear on May 11th of 22, nor did you appear on April 13th of 22. I mean, it's not that hard. We give you a notice, you check out your notice. You can throw your gum in there, man, in the garbage. Right here to him. You have a charge of failure to attend your scheduled probation visit, May the 30th. June the 11th, failed to submit the monthly testing as ordered on April 15th, failed to submit the monthly testing as ordered on May the 6th, failed to provide verification of attending and completing outpatient treatment. 5 charges. Do you understand the charges?
Yeah.
You've had 6 technical violations. Your probation could be revoked and you could be incarcerated for the maximum provided by law in this case, which is 93 days. Do you understand that?
Yes,
Did you sign the advice of rights?
yes,
Did you read it?
yeah,
Did you understand it?
yeah,
If you plead guilty, you'll be giving up all those rights and there will not be a hearing. Do you understand that?
yes.
You have the right to a lawyer. I'll be glad to give you one. Do you want one?
Sure.
I'll enter a not guilty plea here. We're going to give you a date. Actually, we can give her a new date, Lisa. You live in Taylor, ma'am?
Yeah,
I still have Garrett to do with you, right, Mr. Mahikian?
Yes, sir.
You want a new date? I'm sorry.
Yeah, I'm just going to set this over.
Okay, July 8th at 9:30.
July 8th at 9:30. Okay? July 8th at 9:30 will be your court date. Do you
so
understand?
just bring all my paperwork. Yeah.
Yes, ma'am.
Thank you.
I'm entering a not guilty plea. Appoint her a lawyer. And you'll see your lawyer next time. I want you to get a lawyer, okay?
Okay.
Good luck. Amanda Justine Garrett, 25T700567. Ms. Garrett, your name? Is she out there, Lisa?
Yeah, hold on. It went into the breakout room.
Let me do
Why
this.
it's doing that?
People against Rodney Sean Tuttle. 25B701485. Your name, Sergeant?
Detective Sergeant Morrison, Brownstown Police. Can you hear me okay, Your Honor?
I can. Raise your right hand. You solemnly swear or affirm under penalties of perjury, the testimony you'll give in these proceedings be the whole true self you got.
Yes, Your Honor.
Okay, go ahead.
Your Honor, for the purposes of this reading, the defendant was identified as Rodney Sean Tuttle, a white male, 10/27/1986. This incident occurred at 27019 Bathurst Drive, Brownstown Township, Wayne County, Michigan, on 8/21/24 at approximately 7:54 hours. The following report was completed by reviewing reports and body worn camera footage of other officers in addition to Detective Sergeant Morrison's own investigation. Officers were dispatched to location in reference to a domestic disturbance. Upon arrival, they met with a caller and were directed to a male, the defendant Tuttle, who was shouting across the street on public property on a sidewalk. The defendant was agitated and would not stop walking away from uniformed officers who directed him to stop. He became physically combative and punched Officer McParland in the head when Officer McParland tried to restrain him. A brief foot chase ensued and Tuttle was taken to the ground where he continued to resist. Defendant Tuttle assaulted Officer McParland by grabbing him and assaulted Officer Nowick by squeezing and pulling her fingers, causing fractures in her hand and fingers. The defendant also dropped an item out of his pocket in the presence of officers, which was later confirmed to be methamphetamine. The officers involved were Officer McParland, Officer Nowick, and Officer Grimm. Civilian witnesses, relatives of the defendant, witness Mary Jackson and witness Bryce Jackson. On 8/21/24 at 7:54 hours, officers McParland, Nowick, and Grimm were dispatched location for a domestic incident that occurred. When Officer McParland arrived on scene, he made contact with witness Mary Jackson, who stated that her daughter, witness Bryce Jackson, was possibly assaulted by her brother, the defendant, Rodney Tuttle. Defendant Tuttle was across the street yelling at Officer McParland that he did nothing wrong. Officer McParland advised the defendant he was detained for investigation. Defendant Tuttle refused and started to walk away. Officer McParland told defendant Tuttle numerous times to stop, but he did not comply. As Officer McParland reached out to grab the defendant's wrist, he pulled away from Officer McParland. Officer McParland reached again for his arm, and the defendant punched Officer McParland on the right side of Officer McParland's forehead. Officer McParland fell down to the ground, and the defendant took off running northbound on Kirby Road. Officer McParland chased the defendant to the front of 23432 Kirby, where Officer Grimm and Officer McParland tackled the defendant down to the ground in a cement driveway. While the defendant was on the ground, he continued to fight with Officer McParland, Officer Grimm, and Officer Nowick. Officer McParland delivered a knee strike to defendant Tuttle to the ribs to get him to surrender his hands. Officer McParland mounted on top of the defendant to pin him to the ground and struck defendant Tuttle in the face while trying to take him into custody. The officers were eventually able to secure the defendant in handcuffs to take him into custody. Officer McParland had observed the defendant drop an item out of his hoodie pocket while he was running. Upon examining this item, the officers observed that it was consistent with narcotics, a white substance in a small plastic bag. It was collected on scene by Officer Grimm. Officer Nowick observed the defendant punch Officer McParland and then run when the incident began. After the defendant was taken into the ground, defendant Tuttle was refusing to comply with multiple clear directions to stop resisting and surrender his arms. Officer Grimm was able to pull one of the arms out from under the defendant, and Officer Nowick was able to place one handcuff on the subject's wrist. The defendant then grabbed Officer Nowick's left hand, twisting Officer Nowick's left hand, trying to pull Officer Nowick to the ground. Officer McParland was able to retrieve the defendant's other arm, and Officer Nowick used a second hand, and they were able to handcuff the defendant. Officer McParland sustained multiple abrasions on both of his arms, hands, and knees as he was trying to take the defendant into custody. Both Officer Nowick's hands had abrasions. She had an abrasion on her right knee. Officer Nowick's ring finger and pinky, her left ring finger and pinky were swollen and began to bruise. Officer Nowick did receive medical attention, and the following injuries were diagnosed at Concentra in Woodhaven: contusion of the left hand, contusion of the left little finger, contusion of the left ring finger without damage to nail, fracture of a proximal phalanx of the left little finger. A forensics analysis on 10/1/24 by MSP scientist Michelle Rockwell revealed the following results for suspected narcotics collected by Officer Grimm. Methamphetamine, 1.24 grams. It should be noted that officers on scene arrived in fully marked police Chevrolet Tahoe units. They were in police uniform. Multiple officers were giving commands at different times to stop resisting, and giving specific commands. The defendant was verbally and physically resisting and assaulting officers while they were trying to detain him and arrest him. The defendant Tuttle can be seen clearly on footage grabbing and squeezing Officer Nowick's left-handed fingers while pulling his arm towards himself as she cries out and shouts at him to let go. I have nothing further, Your Honor, but I would like to amend the date that I signed to today's date, which is 6/24.
Yeah, I changed that. I'm authorizing the issuance on the assault, resist, and obstruct an officer causing injury. That's count 1 4-year. And then we got assault, resist, and obstruct an officer. Count 2 involving Officer McParland, and then possession of meth, count 3. So I'm authorizing, I'm signing, and we'll put the warrants in the lien. Have a good day. Thank you.
Hey, thank you, Your Honor. Be safe.
2, Amanda Garrett. Amanda Justine Garrett, I need Emily, 25T700567.
Good morning, Your Honor. Will Hickey, Kit 1520 on behalf of Ms. Garrett, who is present via video. State name for the record, Ms. Garrett.
Yes, I can't hear him that well. Can we turn it up?
You state your name for the record. Mr.
Your name, ma'am, we need your name.
Amanda Garrett. Sorry, I couldn't hear.
That's all right. So now she has, 2 counts. How is she going to proceed on these?
Gonna plead guilty, Your Honor.
If you plead guilty here, this would be your first 2 technical violations. You could get 10 days. Do you understand that?
I do understand that, Your Honor.
And you understand all the rights? Again, you have the right to remain silent, right to testify, right to bring in your own witnesses, right to use the subpoena powers of the court to bring in those witnesses.
I do understand that.
If you plead guilty, you're giving up those rights, you're waiving the presumption of innocence, you're waiving the requirement that they prove you guilty by a preponderance of the evidence, and that would go down as a probation violation conviction. Do you understand that?
I do understand that, Your Honor.
All right. If you plead guilty, you're giving up those rights. I'm now going to ask you as to count 1. Failure to submit the weekly testing is ordered on June the 6th. How do you plead?
I do.
How do you plead? How do you plead to that?
Guilty.
Did you fail to submit the weekly testing as ordered on June the 6th?
Yes.
Is to count 2. Did you fail to provide written verification of attending and completing intensive outpatient treatment? How do you plead?
I plead not guilty. They were supposed to send it over, but they never did.
To complete intensive outpatient treatment?
I've been there 9 times and then I transferred over to inpatient treatment. The psychiatrist was supposed to send over verification.
I only sentenced you a month ago, right? 5 weeks ago.
Yeah, I've been there at least like 8 times, at least 7 or 8 times. I go 3 times a week.
Slow down. The charges that you didn't.
But I started going to outpatient treatment before you sentenced me.
I believe you. I believe you, but just listen. The
Okay.
charge is that you, who have the responsibility to do so,
Yes.
fail to provide verification of attendance at IOP. You still
Yes.
want to be not guilty.
Didn't you tell me to?
Listen, wait a second.
Yes.
Whoever that is cannot be conferring with you.
Okay, I'm sorry. Yeah, not guilty.
Hang on, slow down.
Oh, I'm sorry.
I ask the caseworker manager to exit the room, please.
Your Honor, I think
Okay.
it's a little confusing. I did say I was gonna ask if the court would get rid of that due to the fact that she had been going to outpatient.
I know, but I want the case manager out of the room. Thank you.
I do have some information that will make it make more sense.
Okay. Your name.
Emily Casino.
What do you want to add?
So no, I did receive documentation that she started intensive outpatient on May 7th of 25. But then on June 9th, I received notification from her supervisor at New Oakland Family Services that she was discharged unsuccessfully because she missed 3 times in a row.
All right, so here's the deal. You can plead not guilty and we can have a hearing. You can plead guilty or you can plead not guilty. If you want to plead not guilty, that's fine. I'll swear her in and I'll make a determination as to whether or not you failed to provide verification of attending and completing intensive outpatient treatment.
Okay, I plead not guilty.
All right, raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you give in these proceedings will be the whole true self you got.
Yes, Your Honor.
Just so there's no misunderstanding, I'm accepting the plea as to count 1. We're proceeding on the hearing as to count 2, failure to provide verification of attending and completing IOP. You can go ahead.
So just as I stated, I have an email from Kaylee Wiley. It's dated June 9th, 2025, and she states in the email that Ms. Garrett did not show up for IOP today. And with it being her 3rd time in a row that she missed, she would be discharged from IOP as of today.
And that was dated the
My
night.
email is dated June 9th, so she missed June 9th, which was the 3rd time in a row.
Okay. Any questions over Mr. Nahiki?
Do you know when she started the inpatient treatment?
So then she started the inpatient treatment, it was detox. She went June 11th of 25.
All right. Any other questions?
No, you're.
Do you wish to have your client testify? Okay. I mean, it's pretty clear here, ma'am. I don't need to have argument. You were discharged from the program because of non-attendance. And I'm gonna find you guilty as charged on that. Now, where's she at inpatient wise?
She's in California.
California?
Yeah,
So I do think she relapsed and took the necessary steps to get back on track, so I do give her credit for that.
Whereabouts in California are you?
Simi Valley.
Wow. Okay, go ahead.
I was just gonna say, I mean, it would probably be complicated with her being there, so the letter states 45 days, I mean, we do have quite a bit of time with her just being sentenced. I don't know if when she comes home, if sobriety court would be a good thing for her, I think she's someone.
Could be, Ms. Garrett.
Struggles.
What was that?
I can get you in our sobriety court. You don't have. I can get you in our sobriety court. We can help you. Here's what I'm doing. If, did you say the 11th she went in?
Yeah, so that's where it gets sticky, so we'll kind of lose a little bit of time, but.
That's okay.
Yeah, June 11th, and it says that, she'll receive 45 days of service.
I want you in my sobriety court. I want to adjourn this. I'm going to adjourn it, okay? I'm going to adjourn it, the sentence. And we're going to make it, good boy. Give me about 30 days out, Lisa.
July 22nd at 8:30.
July 22nd at 8:30, and then I'm going to find out how you're doing over there. Okay, Ms. Garrett?
Yeah.
All right, hang with it. Can I see the screening report real quick? I think sobriety court would be the perfect fit for you.
Okay.
First offense, but she's been very forthcoming.
I know, and I appreciate that. 38. You went to Penn State.
Yes, I did.
What are you gonna do with that? You were smart enough to get into Penn State.
Yep, and I went to nursing school as well.
All right, let's get your life back on track. Take that. We'll see you July 22nd, okay?
Yes, thank you, Judge McNally.
I wish you well.
Should we
Stay
do
with.
Thank you.
later?
I will.
So wait.
Should we do later in the day with the time difference?
Oh, yeah, it's gonna be 5:30 in the morning there.
Good catch, Tab.
I
didn't think
know.
about that.
Let's do it, Lisa, let's do it at 11:30, okay?
Okay.
Thank you for taking that into consideration.
No problem. July 22nd is what day of the week? Is that a Tuesday?
It's a Tuesday. Mr. Nahikian will be here.
Good, perfect. Thank you. We'll see you then. Good luck.
All right,
Thanks.
thank you.
Thank you, Evan.
Thanks a lot.
Do I just leave the camera and stuff off until she comes in?
Just mute yourself and just stay there.
Okay.
Good morning.
Morning.
We're on the record in the 13th Judicial District, the District Court of Greenwood, County, Kansas. This matter does come on for hearing on the defendant's motion to suppress evidence. Please announce appearances.
Date appears by Jill Gillette, County Attorney.
Richard Paul on behalf of Miss Cowan,
Christy Cowan.
who appears via Zoom at a separate location than council.
Ms. Gillette, I saw that after the motion was filed, there was an amended information. Did you file a written response to this motion?
Judge, I just submitted just written factuals just to keep what my facts are and arguments, and that we just filed.
All right, so are you ready to proceed?
We have Deputy Fisher here and we're ready to proceed.
All right, and Mr. Paul, you're ready to proceed?
Yes, Your Honor, thank you.
You're welcome. The burden is on the state with this motion, so please call your first witness. Deputy Fisher, if you'll raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you. Please proceed, Ms. Gillette.
Could you please state your name for the record?
Deputy Blake D. Fisher,
And Deputy Fisher, how long have you been employed by the Greenwood County Sheriff's Office?
since December of 2019.
And Deputy, what is your, where were you on duty when you noticed the defendant?
I was on US Highway 400 at V Road in Greenwood County.
And have you, can you describe for us a little bit what V Road looks like?
It's a 4-lane highway, 2 lanes going eastbound, 2 lanes going westbound. I was sitting in stationary patrol facing northbound at the time. The defendant was going eastbound.
And in this area, which direction was the defendant traveling?
Eastbound.
And when you were, what drew your attention to the vehicle?
As I was sitting in stationary patrol, I had my high beam headlights activated, which helps give me a better visual to seeing the vehicles as they pass by. As she passed by, I could not see into the vehicle as the window tint appeared to be too dark.
Now, have you had experience with window tint before?
Yes.
And is it something that you deal with frequently?
Yes.
And is this area of the highway a dark area of the
It
highway?
is. There's little to no light.
Okay. What is straight across from V Road?
And rural county road.
Is it near the Severy Rock Quarry?
Yes, it is.
And uh, Your Honor, I admitted my laptop for purposes of sharing a few things, the video, and in particular, a photo that has to do with the map of the area.
Very well.
I'd asked to be able to share that.
Any objection, Mr. Paul?
It's just a map. I don't have an objection. I haven't seen this map, so.
Okay.
And I don't know why it's not showing up there. Missy, do you have to click share screen?
I can see it.
Okay. Is this the area that you were sitting at, Deputy Fisher?
It was.
Okay. And what is the area down below on the south side?
That's the rock quarry.
Okay. And where were you specifically sitting?
Right at the intersection.
Okay. And which direction were you facing?
Northbound.
All right. Now, Deputy Fisher, were you operating a vehicle that had a dash camera in it?
I was.
And was your dash camera on and running for this stop?
As to my knowledge, it was, yes.
Okay. Your Honor, I would like to, and when you provided your dash camera to the state for this case, is it a true and accurate depiction of what your dash camera was seeing?
Yes.
Were there any modifications, corrections, or additions made to it?
Not to my knowledge.
Does your dash camera split up into sections?
At that time, yes, it did.
Okay. Do you have a new camera system now that does something different?
Yes.
Okay. So at the time, you still had the old dash camera system?
Correct.
Your Honor, we'd like to admit and play the dash camera of Deputy Fisher. That's the beginning of this stop. There'll be two separate videos, a first one, then a second one.
No
No
objection.
objection. Granted. Will be admitted. And did you say you're gonna play that now?
Yes, Your Honor.
Okay.
Deputy Fisher, do you conduct different kinds of window tint stops?
As in,
Are they during the day and night?
yes, at times.
Okay. And how do you know when window tint is too dark when it's at night?
By my high beam headlights, like I stated, I usually sit with my stationary when I'm stationary with my high beam headlights activated, which allows me visual into the vehicle, and I could not see into the vehicle as she passed by.
Okay. And is that something you've learned by experience or you had training on?
Both.
And in this case, did you later test her window tint?
I did.
And what did the window tint turn out to be?
Approximately 11%.
And what is the required percentage that windows should be?
35.
After you made the stop for the window tint, what was the next thing that drew your attention?
As I approached the front driver's side window, she had only rolled.
Judge, I'm gonna object relevance. We're here.
Overruled.
What was the next thing that drew your attention?
She had only rolled the window the window partially down.
And did you speak with the driver
I did.
after you noticed that she only rolled the window partially down? What was the next thing that you observed?
She actually had a warrant out for her arrest out of Butler County that was associated with the tag of the vehicle.
And was the registered owner the one that had the warrant?
Yes.
Okay. Is that something that comes in when you call in the tag?
Yes.
Had you already called in the tag?
Yes, I had ran it through my in-car terminal and through my dispatch.
And knowing that the registered owner possibly had a warrant, were you able to confirm that it was Cohen that was driving?
I did.
And did you notice anything about her person after you approached the window?
Judge, I'm still gonna object.
Okay, I gave a little leeway, but the motion is basically limited to whether he had authority to stop or not. So I think at this point, I'm gonna sustain.
Your Honor, I believe I will pass this witness to the defense.
Mr. Paul, cross-examination.
Thank you, Your Honor. Deputy Fisher, you you filed an affidavit. An affidavit was filed that you made concerning this stop, correct?
Yes.
Okay, and in that affidavit, you do not put that you had your high beams on, correct?
I don't believe I did, no.
No, but your testimony now is that you had your high beams on.
Correct.
Okay. When we watch the dash cam footage, there are basically three cars that pass your frame of vision before before Miss Cohen's car drives by, correct?
From what I could tell.
Yeah, and could you ascertain whether those cars were legal on window tint?
No.
No. But your testimony now is that you were able to ascertain that Ms. Cohen's car was not compliant, correct?
Correct.
Okay. Now let's go back. It was very dark out that night, correct?
Excuse me 1 second. I apologize. You said Mr. Paul.
Yes, it was very dark out that night, correct?
Correct.
Okay, and your previous testimony was that there was little to no light.
Correct.
And we saw on the dash cam how dark it was outside, correct?
Correct.
And according to your affidavit, you pulled her over at approximately 9:24 at night, correct?
Correct. If that's what states in my affidavit.
It does. So, and also your previous testimony is that you said you ran her license plate on your in-car terminal, correct?
Correct.
But in your affidavit, that only happened once the vehicle was completely stopped, correct?
Correct.
So you did not run it while you were in pursuit of Miss Cohen, correct?
I did not know.
Okay. Um, would you agree that sunset that day was approximately almost 4 hours before your stop?
I don't know when sunset was.
Okay, but it's in January, so it gets dark early.
Correct.
Isn't that true?
Correct.
Okay. And so your testimony is that when she drove by at highway speeds, you were able to ascertain whether or not she was compliant in her window tint, correct?
Correct.
Were all the windows tinted?
From what I observed when I was sitting there, it was her right or front passenger window, and that's the window that I tested. I could not see into that side of the vehicle at all.
Okay, but you were able to look through the back window.
I don't recall. It was as you said, she was going at highway speeds, and the first
And
window that caught my attention was the front passenger window.
And according to your affidavit, that was the only reason that you pulled over Miss Cohen that night, correct?
Correct.
You did not observe her having any other type of traffic violations that would warrant you pulling her over, correct?
No.
Judge, I have no further questions.
Redirect, Ms. Gillette.
Deputy Fisher, if there had been window tint issues with one of the cars previous to Ms. Cohen, would you have pulled it over?
I mean, most likely, yes, but it should also be noted that Miss Cohen was the closest vehicle to me at that time. From what I could tell, all the other vehicles were traveling westbound, so that would have been across two other lanes of traffic, and Miss Cohen was the closest lane to me when she passed by.
And do you do window tint stops both at night and during the day?
Objection, asked and answered.
And do you know every single minute detail in your affidavit, or is an affidavit used to number one, document the thing and the stop or incident, and does it like contain every single solitary detail of how you conduct an investigation?
It only, depends on how I write it at the time, but no, it does not pertain every single minute detail.
And when you look at tags as they go by, are you able to tell if they're Kansas or a different state?
90% of the time, I'm able to tell.
And is it different for officers that are trained than probably civilians?
Correct.
Is that something that you get more and more experience on the longer you do it?
Yes.
What about the window tints? Is that something you end up with more experience on as you do it?
Yes.
Now, I spend more time with officers than probably other people do, but are you able to kind of tell the speed of a vehicle just by looking at how it's traveling?
At times, yes.
So would you be able to tell if the vehicle was traveling faster than normal?
At times, yes.
Your Honor, I will pass this witness.
Recross, counsel?
Yes, Your Honor. Deputy Fisher, when you saw those other cars passing by, even though they were on the opposite lane, they were still close enough for you to see the window tint, correct?
Yes.
I have no further questions.
Okay. Any further evidence, Ms. Gillette?
No, Your Honor, the state will rest.
Mr. Paul, any evidence?
No, Your Honor, thank you.
Any argument? Ms. Gillette?
Your Honor, window tint is sufficient and enough to stop a vehicle, whether it's at night or during the day. Deputy Fisher has explained how he knows when a window tint is off at night. He has lots of experience doing it, both in the daylight and in the dark. He could tell that the window tint for Miss Cohen's vehicle was too dark. The passenger side window drew his attention. And that her car was closest to him. It was easiest to tell that if the window tint was working or not. It didn't matter about whether there was a moon, whether there was dark. It has to do with how it reflects with his high beams and whether or not he can see into the vehicle correctly. It's something he has experience for. It is the totality of the circumstance of the officer at the time, based on their training and experience, based on Deputy Fisher's training and experience and the techniques he has learned and had experience utilizing as to whether or not window tint is too dark was used in this case. It matters not whether there were other vehicles in the area. This is not something that has to do with speeding. This has to do with her specific windows and window tint. Had he noticed it on a different vehicle, he probably would have stopped that vehicle, but he did notice it specifically on her vehicle and that it was her window tint. Officers don't have to log down every minute, tiny detail of their experience and training. That's why we have these kind of hearings, so they can testify to their training, their experience, and how they do these things to know. The windows were later tested and they were confirmed to be above the window tint too dark at 11%. It should be 35% or more visibility. And so it is confirmed. She is charged with the window tint violation. Though that is not necessary. The state can choose not to charge the lesser reasons for the initial stop, especially when other things are found. And as soon as Deputy Fisher ran her tag, he knew that she had a warrant and that he would be able to take her into custody if she was driving her registered vehicle to her. I would say that we can't substitute our experiences as civilians for those of trained law enforcement officers who have both training and experience.
Thank you. Mr. Paul, any argument?
Yes, Your Honor. Your Honor, I would ask that you grant our motion to suppress. Judge, you saw the dash cam video. It was very dark. I mean, Deputy Fisher, even though he testified that his high beams were on, he failed to mention that in his affidavit. I mean, I think the state argues that that's a minute detail, but that is an actual very important detail if that is the case. Judge, there were 3 other cars, and it's arguable that some of those had window tint that Deputy Fisher could not ascertain whether they were compliant or not. Judge, he acted on a hunch. The hunch is not reasonable. He didn't notice any other type of traffic violation at all. There were other cars that may arguably have been violating the law as well. And for him to get lucky after the facts that they were too dark has no materiality in this case, Judge. I don't believe if it was a daylight stop, we probably wouldn't be having this argument, Judge. But as you saw, it was pitch black out there. And for him in a 1 second to determine that Miss Cowan's window tint was too dark, the defense believes that the search and the seizure were unlawful because he had no reasonable articulate suspicion to initiate the traffic stop. So Judge, the state talks about the totality of the circumstances. If you just look at that dash cam alone, Judge, I believe that shows that our motion is correct and it should be granted. And that's all I have.
Well, this is a motion, I believe, appropriate before the court because there is the legitimate question, considering it was dark and the points that defense counsel brings out, no full moon or any such thing. Granted, if I were sitting where the officer was located, I probably wouldn't know one way or the other. I don't have the experience at looking at and judging half the things officers are required to. But in this case, the officer does, through his testimony, have training and he has experience to notice things that I wouldn't. One of them being the window tint. And he testified, and I found incredible that with his high beams, he could tell if the window tint was too dark or not. That window tint is very important to those officers out there because they need to be able to see into that automobile and make sure somebody's not sitting there with a weapon pointed at them or putting them in harm's way. So they are going to be more observant to such things as a civilian would. And this officer not only is observant to it, but he's trained and experienced. He has done stops but at dark before. This car was the closest to him, right in front of his headlights. And if he couldn't see in, he couldn't see in. So I find that he did have reasonable grounds to make the stop, to seize the motorist, if you will, and to proceed on his investigation from there. Anything, though, after the stop, I agree with Mr. Pye. It's not relevant to the motion that he ran the tag and so forth, because that all did happen after the stop or the seizure. But at this time, I'm not going to suppress the evidence gathered from the seizure because I think it was legal. I find the officer credible that he did note that the window tint was too dark. He made the stop for that reason. And the fact that it was only 11% visibility in the car shows that he knew what he was looking at, that it wasn't, or that it was too dark to see in there like he needed to. So motion is denied at this time. And how do we want to proceed next? Do we want to set this for trial?
Judge, they put an amended count as a felony. We need to set this on the PHC docket.
Let's see, they did file amended information. That was
Yeah.
filed June 24th. And yes, they amended it at count 1 to driving under the influence, a third, alleging that there was a prior Butler County 24 TR 2429 and a prior Mulvane Municipal conviction on 215 of 13. So we need to set this on the PHC. I would agree, Mr. Paul. Missy, what do we have for PHC? And if you want to set it for evidentiary directly, we can forego a PHC as well.
We'll do PHC for now, Judge.
Very well. Missy?
July 18th available?
July 18th at 1:30.
Yes.
All right. Ms. Cowan, I'm going to continue your bond. Mr. Paul, you are available that day?
Yeah, yes, Judge. Judge, I will need an order pointing on the felony.
Yes, you will. All right. So Missy, if you'll make sure he gets that for bids. Board of Indigent Defendants. And Ms. Cowan, as I said, I'm going to continue your bond, all existing conditions, but I'm also adding the condition that you reappear with your counsel July 18th at 1:30 by Zoom. And and that will be for preliminary hearing control. Anything else from either party?
No, Your Honor.
Not from the state. Thank you.
And Langston, you've got Leon Goodman, the third.
He's hired a lawyer. He's here.
Where's,
I've checked this morning.
They told me this morning, the mom was here, said she heard something about
probation?
that's his mama and that's him. Saw outside, first thing she said is she got somebody. Who's the lawyer you hired?
I talked to attorneys, I talked to Robinson, and I talked.
Who did you hire?
Who did you hire? Jaws Cole. Giles. I think he's out of order.
When did you hire him?
9580 something of
I can't, he's my, like, when did you hire him?
Friday. So,
When, did you give him like, the notice of your
he said he was
appearance?
sending it through.
Sir?
He said he was sending it through yesterday morning.
Well, if he, we don't have anything from
He
him.
hasn't e-filed anything into the case yet, as far
Yeah,
as I can tell.
you have his phone number, don't you? Call him up. Tell him he needs to be here to help you. I mean, if he's representing you, he needs to be here. We don't do it by telepathy. You got to be here in person. And something needs to be in the file. He knows it needs to be in the record, and there's nothing showing that he's representing you. Until such time that happens, Langston Adams continues to represent you. You can say you hired somebody, but you've got to show with writing and records that that's been done so that it's official. Otherwise, the way the rules are, he continues to be the attorney. But call him up and we'll wait. You know, we got other things to do, but call him up and tell him we're waiting on him. I think we've got two lawyers working on this. We've got Langston Adams. Three.
My bill, I'm sitting.
Great.
I just said.
Okay, come on up. David Grove and Reagan Minaldi for handling the three handling matters. This is going to be Javon Gilbert.
I'm sending in the link to you now.
Thank you.
Thank you, Judge. I'm sorry about that. I'm trying to resolve.
Okay, that's okay.
I think we got it done.
You jump on Javon Gilbert. That's you, ma'am?
Yes, sir.
Okay, which one are we going to dismiss?
9-8, Your Honor.
Okay, so we take up first 24 CR 1399. And you were Javon Wilshon Jobert, present with your attorney, Mr. Adams, and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment here? And can we proceed in a summary fashion?
Yes, sir.
What do you need, a pen?
I need a pen. I got one. Thank you.
Here. That'll be $10.
Tim, I got you. No problem. Just go ahead. Listen.
In summary, this indictment alleges that on or about June 3rd, 2024, in Jefferson County, Texas, you committed the second-degree felony of assault on a peace officer by striking the peace officer about the face with your hand as he was in the course of arresting you. You understand what you're charged with here?
Yes, sir.
This is classified as a second-degree felony. And what that means is if convicted, this says y'all checked third degree. What is it? The second degree in the caption.
He's second degree.
Yes, Your Honor, that's correct.
Is that wrong? Let's fix it. A second degree felony, in this case, that means you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
The agreement's been reached in your case where you
pleading guilty, placed on deferred or unadjudicated probation, fined $500. That can be up to 10 years in length. And as part of this agreement, 24 CR 1398, attempting to take a weapon from an officer, that is dismissed. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this second degree felony of assault on a peace officer? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
Show you what's marked with State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Did you understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it is admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. State's Exhibit 1 was made a part of the record for all purposes. Is a pre-sentence report waived here?
Yes, sir.
Stand by just, sir. What was going on here? What was going on?
Oh, I went out with my friends and coworkers and things like that, and I ended up getting a little too drunk.
I'm sorry, say that again?
I went out with my coworkers,
Uh-huh.
to like a house party, and I ended up getting a little too drunk, and I
A little
didn't
too
drive
drunk.
home. I didn't drive home. I had pulled my car up closer to like besides of like somebody's parking lot, and I just slept in my car. And then, but they what I was told was somebody seen me in my car and they thought I was dead or something, so they called the police. Then when the police came, it was
Okay. Are you aware of what really happened?
oh, as far as the altercation with the police is?
No, this whole thing. What time did the police come up to see you and to help you? Do you know?
It's probably like most 6.
5 a.m.
Oh, okay.
You're parked in a vacant lot on West Grove Circle in Groves. Your engine is running and you're out. You're lucky you didn't die of carbon monoxide. They saved your life, probably. So let's see. So they were helping you out of the car and you began punching the officer with a closed fist. And let's see, you were taken to the ground, continued wrestling and kicking the officers. This was just alcohol? Nothing
Yes, sir.
else?
Yes, sir.
Mhm.
No medication.
Is
no
that normal?
drugs.
Is this normal behavior for you?
No, sir. Intoxication.
Well, the car was running when they found you. You're lucky you didn't die. And this is 4:57 in the morning. Okay, so you were arrested. How long did you stay in jail?
The day too.
Gonna be more than that. You don't punch officers on my watch. You don't strike the officers like this. Who's saving your life? That's incredible. All right, anything else?
Nothing.
All right, I'm going to find it then, and you are pleading guilty in this case. Is that correct?
Yes, sir.
Are you pleading guilty voluntarily,
Yes, sir.
knowingly, intelligently, and because you are guilty?
Sir.
All right. State's Exhibit 1 has been admitted into evidence without objection. And I'm going to follow this agreement and find that you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, but I'm going to defer any finding of guilt and place you on deferred or unadjudicated probation for um, 10 years. If you do well, it will be shortened to 1/3, 3 1/3. There's a fine that you must pay in the amount of $500. And how long did you say you were in jail?
Like a day or two.
4 days. You don't even remember, do you?
Well, I didn't.
You were in
think
there,
it was
it says
second
4
day.
days. So you got credit for 4
Yes,
days.
sir.
All right. You're going to do a weekend in jail. Another weekend. I want you to report into the Jefferson County Jail on or before 6 o'clock p.m. They will release you Sunday. No one punches, fights and punches out law enforcement without having to go to jail. You don't do that. They're going to be protected as best they can, dealing with people, especially someone like you who were saving, really your life was saved in a car that was, you were unconscious in running. And it's just incredible that you would, that intoxicated, that you would go and, I guess it was a great thing that a car full of nuns didn't come up and help you. You'd have punched them out, huh? Anyway, you will report on before 6 o'clock p.m. at the Jefferson County Jail for Friday, and they'll release you on Sunday, 1 weekend, to add to the other 4 days. You take care of yourself better than this. That's no way a lady should be acting, responsible behavior for a lady or anyone else or a gentleman. All right, see the probation officer. Thank you. Langston,
I'll take it.
1398 is dismissed. The other case is dismissed on the lady.
Oh, perfect. Thank you, Judge.
Mr. Goodman, you know where you ended up in this, don't you?
Sir.
You tested positive for drugs. And you're going to be arrested. You don't come to court high on drugs. You shouldn't be on drugs in the first place. That's one of your bond conditions. Don't commit a crime. That's the very first bond condition. Come on up. You tested positive for THC, tetrahydrocannabinol marijuana. What's his bond, please? Your bond is revoked. It is now $20,000, and you must have a drug patch as a condition of bond from here on. Do you understand? This is no way to handle a third-degree felony. You're charged with a third-degree felony of injury to a child. You're looking at up to 10 years in prison. So you're going to deal with this in the most irresponsible way possible by using drugs? Foolish. You're not learning anything from this. You're not learning anything. You're not on the right path at all. Okay, so who do we have representing you? Is it Ms. Ryan?
Yes, at least say he hired Charles, but yeah, I'm here, Judge, for,
Anyway, you're taken into custody and next time I catch you with drugs, you won't have a bond. You'll just sit it out in jail until this thing's over with. You understand? All right. Okay.
with something real quick.
We'll take care of everything. Go.
Sit down. Do you need to get something from him?
Yeah.
Okay, the bailiffs are going to take care of that and get it over to you, whatever his personal matters are. Okay? Thank you. Yes.
Please pardon me, Your Honor.
Okay, pardon.
Thank you. Your Honor, I'm here, Leon Goodman. A young man I met over a month ago.
The one I just put in jail?
Yeah, tested positive this morning.
Yeah, yeah. He's in all kinds of messes. You want to look at his file and learn more about this man? He's not what you think. He's got to get fixed. He's heading down the wrong track.
That's what we're trying to do. That's what Ogden wants to do.
Help him, help him.
I will.
He's on the fast track.
Judge.
But I mean, that's what we.
I'll take the case. I'm taking it pro.
Okay, good.
He said he hired.
Huh?
He said.
Says he's hired Giles Cole on the 20th. We make sure, but you and Giles can work together or work this thing out. But he says he's retained Giles, who wasn't even here.
What were the bond conditions you said, Judge?
Just a drug test.
Well,
Yeah, his bond was doubled like it would be in every case, and then he has to have a drug patch that I would do in every case. That's what I did. So
based on what Mr. Samuels told me, I have no objection to leaving the bond at its original amount, but with the other conditions, Judge. Your Honor, because I know its family is strayed for money as far as. He's trying to get his GED. He's back in school, but he's smoking weed, and I told him. So, but he listens to me.
I know, but it's ironic that he's working on his education, but acting ignorant.
At one point, I did too, Judge.
I mean, where's the education going?
I understand.
It's supposed to make him smarter and to make better choices, and but
Judge,
here's what I do is I treat him like I do everybody. Their bonds get doubled. And it's an example that we set, and then the drug patch.
Hodwin's going to be like a mentor for him. Judge. That carries a lot of weight with me, that he's willing to make that sacrifice. And that is why I'm asking you to deviate from your one.
But here's the deal. We got to remember, they're all special people. They're all special people. We open the door for one. We open the door for everybody. This is fair. This is like the scales of justice. What's fair for one is fair for all. And I'm going to treat him like I'm going to treat others. If we're going to treat him differently, everybody else gets treated in similar situations, and that's the way it's going to work. So give me some good reasons why the bond should not be double like normal and customary. Sometimes it's even greater than double. Depends on what they test positive for.
Yes. He tested positive. THC, smoking. I met him about a month ago. He came and did some work with me. I got to know him a little bit better. His mom couldn't pay me. They couldn't.
I understand.
I'm taking the case free of charge.
How well?
I believe.
How well do you know?
I believe in him.
And how well do you know?
How well do we know anybody? I don't know. I said something about him that reminds me of me.
You're taking a leap of faith.
I'm taking a leap of faith. And I will be accountable for. Did he come out? I won't hear.
If we're going to release it, you're going to have a drug patch too as a condition.
Give me a drug patch.
I think he's already.
Here, bring him out. Bring him out. Please, Tommy. Thank you.
Is he?
He's got to get his drug. You've got to have a drug patch before
That's
we can do that.
It's no, Ellie.
Sorry for this.
No,
Send it to.
too bad, too bad.
Shape up. Come on, do with this.
Yeah.
We're going to deal with this.
Yeah. Gotcha.
But don't lose strength. These are important decisions.
Yes.
He needs to
Yes.
handle it responsibly and as a grown up, because he's being dealt with like a grown up. And he's got to take responsibilities and good choices. Hey, Leon.
Yes, sir.
How's it going in there? I wouldn't want to be in there. How many people are in there?
About 30.
30. And they're,
Docket next door.
buddy, they're just, you don't want to live with those guys. right?
No, sir.
How long do you want to stay in jail?
I don't know.
I wouldn't, a minute. Anything you learned here in the last 30, 40 minutes?
I don't want to be here. I don't want to be here.
Yeah, that's your destiny when you use drugs illegally and commit crimes. Do you understand?
Yes, sir.
I mean, do you understand that?
Yes, sir.
It's kind of like a shock probation in there. We pulled you through. We wanted to see how you would sense and understand and appreciate the environment that you have elected and chosen to make by not following the rules. That's your destiny unless you change, not tomorrow, not next week, not next year, but right this moment.
Yes, sir. Yes, sir.
Is that, do you understand and appreciate that?
Yes, sir.
You need to have a drug patch. The bond is going to continue to be the same. You have to have a drug patch before you leave here. Get that, you'll be released
Yes, sir.
on that bond. And then he's got a next event.
You want
But-
to give him 24 hours, Judge, maybe?
He can't get it here, the drug patch. Like he has to go to the place and
Yeah.
put it on.
They send a confirmation to the
Yeah,
court
just-
once he gets it.
They email.
So within 24 hours, if you don't have the confirmation in your file.
It's just a suggestion, Judge. You get it.
Yeah, if they don't have a program that gets you, you got the end of the day.
Yes.
By the end of the day, that what you can do.
Yes.
You understand? And confirm it with the person who puts it on. You'll be then, as a condition of bond, the bondsman will be notified that you have a drug patch so that that can be monitored.
Yes, sir.
But you fail that, and then you failed. You'll be right back there, and that'll be where you sit until we can resolve this, which could take a while. You understand?
Yes, sir.
But we're serious about it. But the thing is, we seem to be more serious about it than you do, and you're supposed to be taking it far more seriously than us. Are you? Are you understanding and appreciating rule following is vital? You don't follow the rules, you get punished. These kind of actions can affect you the rest of your life. If you're convicted of a crime, a felony, it's with you the rest of your life.
Yes, sir.
And doors of opportunity are closed. You don't have the options that you would otherwise have to live out your dream of what you want to do, as long as it's the right thing. You know, you want a good dream, not a bad dream. And absolutely no drugs, no firearms.
Yes, sir.
Following the rules like all of us in this room do. We have to follow the same rules. And you can imagine how accountable I would be, or Mr. Samuel would be, or the prosecutors or bailiffs would be if they got caught doing something. We really be a big target. But we don't do that because there are we come to appreciate and cherish the more important things: freedom and being able to live in a free society and enjoy your freedoms, but follow the rules.
Yes.
All right. That's my lecture as a parent to you.
Yes.
But this is like a spanking. You learn from it. You don't want to do this again because you don't want to get punished. Do you understand and appreciate how close you are to a destiny of failure and a conviction follows you the rest of your life, and you can't it's like carrying a gorilla around. It wears you down. And then you get tired of, no, we're not going to hire you. We're not going to hire you. We're not going to hire you. Get tired of that because that's all you hear. You don't want to lose opportunities. So you've got to live your life making the right choices.
Yes, sir.
And we're going to help you with the drug patch. But it tests positive. Shame on you.
Yes, sir.
Okay, he has the next event, an announcement. Did we give him a resetting? Okay, David, you're still on this, right? I see Ogden's helping you here.
Giles is his attorney.
Oh, that's
But
right.
he hasn't officially hired, so.
Yeah,
Mr. Cole.
until he gets in the game.
Substitution and I'll add you.
And me, I'm
Talk to
taking
him,
care.
because he hasn't done with that letter yet, so technically I don't have him as a.
Okay.
And I can just replace you from like.
Okay.
Well, get your haircut. You know, so you can see. You don't want to be driving dangerously. Where are you in school? It's a GED you're working on, right? Okay, where are you?
I'm at the Texas Workforce.
Yes, sir. Okay, where are you?
I passed one of my tests. I need 2 more to pass so I can go to Lamar and take my official. After I take my official, they put me in a slow pace class so I could function.
Yes, sir.
So now they took me out and I'm going back to the fast paced class.
Okay, I want you to give me, I want to see how you're doing on your tests.
Yes, sir.
I'm gonna be watching you, okay? All right, we got people watching after you.
Yes,
You
sir.
do your part.
Yes,
You gotta do the heavy lifting. We're gonna support you, but don't let us down, yourself down,
Yes,
your family down.
Yes,
Do you understand how many people there are here involved in this, in your decisions? You don't live alone. This isn't just you. You're not on this planet by yourself. You touch a lot of people's lives and they touch you.
Yes, sir.
So don't disappoint others. Don't disappoint yourself.
Yes, sir.
Yeah, you're capable of doing better. That's what's frustrating to all of us. We know you're capable. Do it. We can't drag you across the finish line. You got to run across. Do it. You're capable of winning the race. Okay. Get a resetting and we'll see you back. And hopefully there'll be a lot of good news out here next. Okay.
Yes, sir.
All right, sir.
Thank you.
Thank you. Anything else? We're in recess. Thank you.
We're arresting him.
Yes. He is placed back on bond.